this particular case, to provide some background information, Mr. Thomas was with another individual who was charged with similar crimes as well and is in jail pending sentencing. There was a home that had a for sale sign in front of it. There was already a window that was busted out. The home was in disrepair. It was obvious that no one was residing there. Mr. Thomas did take a few items from the property. There was a foaming stove and some other sort of fencing metal. The purpose of this was to try to scrap these items. Mr. Thomas was apprehended prior to these items getting too far, so everything was returned. I think that Mr. Thomas, during the change of plea, was very forthcoming about what happened. I think that shows genuine remorse. As far as the pre-sentence report, I believe that Mr. Thomas would take the position that he saw the writing on the wall and he didn't have a desire for probation. That's why he did not participate in those interviews. He certainly didn't want to take away anyone's time or take up any resources that could have been spent with other individuals. So that's why he did what he did. But he did appear at the probation department. He knew his bond was going to be revoked if he didn't partake, and he still held his position, which again shows me, I think, that he's taken a reasonable stance on the fact that he needs to be punished for what he did, and that's going to be a prison sentence. I do think that something closer to the minimum range, something closer to the 6-month range would be appropriate given the facts and given everything else that I've outlined, Your Honor. Thank you.
Jeremy Thomas, the law allows you to say whatever you want me to consider before I sentence you. Do you have anything to say?
No, sir.
I'm here from the state.
Judge, as the state discussed in chambers with both the court and defense counsel, the state is recommending a prison sentence. The state is asking for 11 months in this. The basis of that recommendation, Judge, comes from a review of the defendant's record that is before the court. And the state concurs with the 25 days credit.
I've considered the record, the oral statements made, the criminal history, the abbreviated pre-sentence report, my conference in chambers with counsel and probation, and the statements of the defendant and the defendant's counsel. I've also considered the overriding purposes of felony sentencing pursuant to Revised Code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution, along with the public burden. I've considered the joint recommendation of the parties for a prison term. I have reasonably calculated this sentence to achieve the 2 overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society and the victim, and to be consistent with sentences imposed for similar crimes committed by similar offenders, and using my discretion to determine the most effective way to comply with the purposes and principles of sentencing. I have considered all relevant factors, including the seriousness and the recidivism factors set forth in Divisions B through E of Revised Code Section 2929.12. In that regard, there's one factor making the offense more serious, that this was part of an organized effort with another individual who is facing a similar charge in another judge's court. There are no factors making the offense less serious. In terms of recidivism, there are factors that make recidivism likely. The defendant has an extensive previous criminal history and history of juvenile delinquency, which includes roughly 18 convictions for theft, receiving stolen property, B&E, burglary, 7 that include assault, domestic violence, resisting, 4 dealing with substances like drug abuse and OVIs. There has been a rehabilitation failure after previous convictions and delinquency adjudications. I have sent the defendant to prison 6 times. The first time in 2002 was for burglary, F4, 17 months. The second time, 2006, B&E, 22 months, with another B&E for 11 months. That was under one prison number, but 2 cases, multiple counts. Aggravated assault for 18 months in 2010, B&E in 2015 for 11 months. His last prison that I imposed was for breaking and entering, prison sentence of 8 months in 2017. The defendant has failed to respond in the past to probation or community control. The offense was committed under circumstances very likely to recur. In terms of factors making recidivism less likely, the defendant was honest and said he couldn't do probation. The court does find that the defendant poses the greatest likelihood of committing future crimes. Under 2929.13b1, there is no presumption for community control because of the prior prison terms. The court determines that the defendant is not amenable to an available community control sanction. Prison is needed to protect the public from future crime, and a minimum sentence would demean the seriousness of this offender's conduct. The court determines that the defendant poses the greatest likelihood of recidivism. However, he was honest with the court and said he's not wasting the court's time, so I will give him some consideration for that. I'm imposing a definite term of 11 months with credit for 25 days. The 11 is instead of 12, because I made the finding that I can give you the maximum here. You pay the cost of confinement, prosecution, supervision, treatment, and court costs. Upon your release, you could be on post-release control for a period of up to 2 years. They give you rules. You violate their rules, they can return you to prison for 5.5 months, even for 1 violation. All of that time is part of the sentence. If the violation is a new felony, the judge in the new felony case, in addition to sending you to prison on the new case, can send you back to prison on this case for the greater of 1 year or whatever length of time remains unexpired on that potential 2 years of PRC. All of that time is part of the sentence. I don't have it in front of me, but I recall from prior You don't have a high school diploma or a GED, right? All right. So while in prison, you may be offered programming by which you would be able to get your GED, and that programming is normally capped at 8% of time to be served or a certain number of days, but because you don't have your GED or high school diploma, you might be able to stretch that to 10%. As long as you owe any court costs, the state can block your motor vehicle license plates until the costs are paid in full upon defendant is released. Anything further from the state?
Nothing further.
Defense?
Nothing further, Your Honor.
Probation? Good luck.
Thank you very much.
We're adjourned.